Then Han Sahib has said, where is my due process? Where is my right to, if everybody comes before me, asking for right to fair trial. Now we come to the situation, where do we go from here?
And the most important thing is that the allegation has been leveled against the institution, which is more important as far as I am concerned. ये इसके तहकीकात होनी चाहिए या नहीं होनी चाहिए, हम सवाल उड़ा रहे हैं।
और एक चीज और, ख्वाजा साहब has also said one more thing, something important. He said once he's been removed and he's attained the age of superannuation, the matter ends. Now we were hearing some other case.
Yes,
the same issue came up there also.
So, my lord, as far as not following or not conducting the inquiry is concerned, that is contrary to law, and that to my mind would be malice in law, and therefore Article 211's ouster would not apply as far as this petition is concerned. 211, sir. Article 211.
What does it say?
Bar of jurisdiction.
Bar on jurisdiction, my lord.
A number of judgments you said.
So I think that's quite settled. So if the inquiry hasn't been followed, on the basis of it being there being malafide in law, Article 211 does not apply. Therefore, this court would have jurisdiction.
Malafide in law.
No, but malafide in law is basically if the process is not followed. If what the law or the Constitution requires is not followed, it is malafide in law. Not in fact, but in law. So because if that is so, then this court has jurisdiction. So the court can proceed. The court can look into
we are not a substitute for the Supreme Judicial Council.
Of course you're not, but now the question...
We can't say, okay, now please come and give oath and give it on statement.
No, this is
will cross-examine.
This is jurisdictional question. This is jurisdictional question. You're not going to inquire into the matter while sitting as a court. The Supreme Judicial Council's, it is Supreme Judicial Council's remit to look into that matter. But I am just only saying that this court has jurisdiction to hear the petition if the inquiry has not been conducted, 209, and the procedure has not been
crossed that bridge.
So yes. So
yeah,
once that is done,
where do we go from here?
Once that is done, now one fact which was alluded to, and there's a judgment, a two-member bench's judgment in Afia Sher Banu Zia's case, PLD 2023 Supreme Court 510, wherein the two-member bench has held that if a judge has resigned or has retired, the proceedings, if while he was on the bench had commenced before SJC, they would abate. Now, the federal government, I had in another matter stated before your lordship that the federal government intends to file an appeal against that judgment.
Has it been filed?
Yes, my lord, it has been filed. My lord, it has yet to be numbered. I hope it will be numbered today or tomorrow. Now, there are several problems with that judgment, and of course...
If the principle of that judgment is sustained, then it effectively cuts both sides. Then a judge who's been unconstitutionally removed can do nothing.
Now, so in
the meantime, he retired, for instance.
So in this case,
he attained the age of superannuation.
So in this case, the distinction also is that after the petitioner was removed, he had essayed those proceedings before this court, and he had not attained the age of superannuation at that time. So that distinction being there, but that judgment needs to be revisited also by this bench or any other bench in order for the court to then pass the order of setting aside the Supreme Judicial Council's order in this case. Also,
yeah, I'm not clear with you. Are you saying that we should attach that case with this case?
I would submit so, my lord.
Achha. Okay.
And now, if the inquiry process has not been followed, and the allegation, now we don't know what
is remand permissible?
If, my lord,
if you are saying if Afia is sustained, then it probably may not be. Is that what I'm not understanding?
If Afia is sustained, then perhaps in this case, they may still have to, the petitioner may still have an argument to make, which is that he had not attained the age of superannuation when he had challenged the Supreme Judicial Council's order before this court. So there would be that distinction.
I think there is a fact is that the list in some form or the other was before this court.
That's right. So that's what I was alluding to. That if there would still be a distinction as far as this.
If we accept this petition,
yeah.
what will happen? So we simply
Things can happen. Two things can happen. If my lords accept this petition and simply set aside the Supreme Judicial Council's order without remanding it, then he would be treated as a judge who would retire.
We are also concerned about the allegations. What would happen to the allegations?
Suppose, with due respect to the petitioner and his counsel, suppose we set aside the order and he is laughing. All that I said was false. Okay? Nation, I think I'm more concerned that in every case we decide we have to keep half an eye out. कि भाई इसका implication generally क्या होगा? You may want to do something, but it may have wide implications. The other thing is, doesn't the nation want to know one way or the other? What is the position of the federal government on this? Wouldn't you want to, as they say, get to the truth of the matter?
My lord, so I just got called on short notice.
I know that's not fair.
But what I can state here is that now there are certain allegations which are made in this petition, and those allegations, from what I've understood while sitting here, have been denied.
Not some minor allegations, some serious allegations.
Those allegations have been denied, and now obviously this court cannot record evidence, is not the forum for doing it.
There is a solution. Judicial Council, without saying he is corrupt, Supreme Judicial Council, without inquiring into the matter, recommends to the President, reports whatever, remove him. He is removed. Now, naturally, when he filed the petition, he's already stand retired.
That's right.
So I don't think the date would there be. He has got no way to vindicate his honor.
There has to be a way.
Basically, you are saying one way is no, too bad, whether the Supreme Judicial Council inquired into the matter or not. I mean, whether we agree with the findings of the Supreme Court, that's a separate matter. One is at least inquire into the matter. Okay, I may have a higher level of proof, another may be lower, but leaving those technicalities aside, basic inquiry has to be conducted of some form or the other.
Absolutely.
I mean, whether it has to be in accordance with the Qanun-e-Shahadat or...
No, it's the Constitution requires so. I mean, a judge cannot be removed without inquiry.
Are judges entitled to fundamental rights or not?
Absolutely. I mean, it is at the heart of independence of judiciary. Absolutely. Absolutely. At the heart of independence of judiciary has
उसका solution क्या है?
So इसका solution, to my mind,
आप कह रहे हैं कि इसको club करें उस केस के साथ?
उसको overturn करना जरूरी होगा because that would then settle the law. Because in this case, obviously, there was a substantial period of time when the petitioner was removed.
लेकिन बात कहाँ से कहाँ connect हो जाती है?
And his
nobody would have thought this would connect there.
So 3 years. So if he had 3 years to a service left.
No, like I said, suppose he had only 1 day left.
Yes. So in that hypothetical,
I mean,
then
I don't think that's really crucial aspect.
So in that hypothetical, which my lord has just pointed out, I think it is necessary that that point is settled. That the point is settled that even if he stands retired and attains age of superannuation, the matter can still be revisited by.
But that delay we are accountable for in this particular case because it's proceeded so long.